Okay, good afternoon. Good afternoon. I am Trina Jones. I'm the director of the Center on Law, Race, and Policy at Duke Law, and I'm also the proud holder of the Jerome M. Culp Distinguished Professorship. It is my distinct pleasure to welcome you all to the first inaugural Jerome M. Culp Jr. Lecture in Critical Theory. I would like to extend a special welcome to members of Jerome's family and some of Jerome's close friends who are joining us via live stream. Jerome McChrystal Culp was the first African American to receive tenure at Duke Law School. He was a kind and generous mentor, a wise teacher, a devoted family member and friend, a lover of Duke basketball, and a prolific scholar whose work in critical race theory and lat crit theory transformed the legal landscape. In short, Jerome was amazing. On this first day of Black History Month, and in a week when we honor the legacy of Fred Korematsu, it is fitting that we honor Professor Culp. At this point, we could have read Jerome's extensive bio to all of you, but we have a video that was prepared 20 years ago on the occasion of his death. And so instead of reading a bio, we thought it might be useful for you to hear from Jerome himself.
Grandfathers were coal miners in western Pennsylvania. My paternal grandfather was a union organizer in western Pennsylvania. And as a result of that union organization, my grandfather and his family were blackballed from the mine. So he lost his job in the mine in the 20s. My father and his brothers and sister and my grandmother and grandfather sort of migrated from place to place, unable to sustain employment because they were continually being blackballed. That's a perfect example of the power of people to use their market power to, in various ways, influence, and I would say oppress, people who have less market power. So that history always resides with me. I grew up in a company town, a little patch of homes that were owned by the company and eventually bought by miners, including my grandparents and my father. And that sort of agreement with the company town where you used your check at the company store and often people had nothing at the end of the month, sort of shows the power, economic power, that lots of people have. And so I grew up out of that circumstance where the most oppressive employers in the country historically have been miners and steel working companies, and that's been the companies that my parents and grandparents worked in for most of their life. I decided to become a law professor because having grown up in the civil rights era of the 50s and 60s and having seen people like Thurgood Marshall, in my view, change the world through the law, and seeing Martin Luther King argue for legal change, I thought that being a law professor, I could effectuate change in the world.
A fine romance with no kisses, a fine romance, my friend. This is, we should be like a couple of hot potatoes, but you're as cold as yesterday's mashed potatoes. A fine romance you won't.
I'm not as convinced as I was when I was a naive student that law is necessarily the avenue for change. I think law has a role to play for change. But I think that the inherent conservatism of law, the inherent status quo aspects of law, make law only a minor contributor to change. So what I try to tell law students is to remember that part of your role is to support the status quo, but to also remember that you have to figure out ways how to challenge the status quo when it's wrong. And the status quo often is wrong. After all, the same legal system we have now supported slavery, supported the indenture of human beings, supported the subordination of women, supported a very oppressive class structure. And we reject all of those things now. And there are other things that are part of the status quo that we need to change. In essence, what critical race theory has said is that the main assumptions that traditional legal theory makes about the law and race are wrong. Sometimes the real problem is race, and that sometimes the law has to ask the racial question. So critical race theory questions the assumption that is inherent in much of traditional legal theory that we can simply leave race out with a set of simple rules, a set of simple neutral policies. And it says that if we look at the history of law in our society, it's greatly been impacted by a history of race and racism that's gone on for the entire legal history of this country.
The family. While a fine scholar, Jerome Culp was also a fierce warrior, soft-spoken and with a quick mind and a ready pen as his weapons. He was one of those first blacks at law schools with previously all-white faculties. The burdens of those roles far outweighed the honors. Too many years, Jerome at his school bore those burdens alone. His contributions to his students, to the academic community were of a value not easily measured. He responded aggressively when members of the establishment tried to diminish the worth of critical race studies, and he publicly urged a new woman appointed to the U.S. Supreme Court not to follow in the footsteps of her predecessor. And he courageously set forth in some detail the reasons for his admonishment. Few of us would have been so bold in stating what so needed to be said. Jerome's contributions were many, and there is no doubt that he will be missed. The only question is whether those of us who survive him will be able to emulate his model. Attempting to do so is both our challenge for those he leaves behind, and rising to that challenge is likely a memorial that would both please
Good afternoon, everyone. I'm Giovanni Martinez. I'm the Executive Director for the Center on Law, Race, and Policy. I'm also a Senior Lecturing Fellow here at Duke Law. Again, good afternoon and welcome. Welcome to this inaugural lecture on critical theory. It is a pleasure to have you, and it's also a pleasure now to introduce Robert S. Chang. He's a professor of law and founder and executive director of the Fred T. Korematsu Center for Law and Equality at Seattle University School of Law. Professor Chang primarily writes in the area of race and interethnic relations. He is the author of Disoriented: Asian Americans, Law, and the Nation State, a 1991 NYU Press book, and Minority Relations, Intergroup Conflict and Cooperation, a 2016 University Press of Mississippi book. Professor Chang has published numerous articles, essays, and chapters in leading law reviews and books on critical race theory, Lat Crit theory, and Asian American legal studies. He also is currently completing two co-authored Cambridge University Press books titled The United States Supreme Court and White Social Dominance and Banned: Fighting for Mexican American Studies in the Streets and in the Courts. Notably, Professor Chang is an elective member of the American Law Institute. He has received numerous recognitions for his scholarship and service. And while I won't enumerate all of them, I will highlight two. The 2021 Kathleen Taylor Civil Libertarian ACLU Washington Award for his role as co-counsel in representing Black Lives Matter Seattle King County. This was a lawsuit against the city of Seattle for its use of force against people protesting police brutality following the murder of George Floyd. And the second, the 2018 M. Shannara Gilbert Human Rights Award by the Society of American Law Teachers. That award recognized him for his work as co-counsel in taking to trial, successfully, a constitutional challenge to the enactment and enforcement of a facially neutral law that was used to terminate Mexican American Studies at Tucson Unified School District. Today, however, Professor Chang is home, as he is a Duke Law alum. And Professor Chang is a former mentee, colleague, and friend of Professor Jerome Culp. Ladies and gentlemen, please give him a special applause.
Thanks, Giovanni, for the very generous introduction. And of course, I'm only going to talk about the cases that I won. I'm not going to list all the cases that I've lost. It is great to be back. And I haven't been back for 20 years. And the last time I came was actually for Jerome's memorial in 2004. So it's hard to be back. I'm so honored to be asked to do this. But it's also hard to do it because of my friendship with Jerome. And then last night, they told me that some of Jerome's family was going to be on the live stream. And maybe it's less pressure than if they were in this room, but that's adding to the terror that I feel right now. So I thought I would begin by saying Happy Fred Korematsu Day, January 30th. 7 or 8 states now have recognized it into perpetuity, so it's a day that honors civil liberties and the Constitution. North Carolina doesn't have one yet, so if there's a practicum here or a clinic that wants to put this forward, I'd be happy to put you in touch with people who could make that happen. Now, when Trina asked me, did me the honor of inviting me to give this inaugural lecture, one of the first things that I did while I was on the phone with her was to pull out one of the books that Jerome had sent to me, Salvation, Black People and Love. And then while I was on the phone with her, I opened it up, and I found this e-ticket. And the e-ticket is from 2005 February, when some of us met Jerome's brother, Jim, to spread his ashes on Maui. And then I opened it up. It's like I actually wrote something on the way over there. And so if you'll indulge me, I'll just read what I wrote back in 2005. Several years ago, Jerome began giving me books about love. I wasn't ready then for the lessons contained in them, so these books sat on my shelves unread. I finally came around to reading one of them on the plane ride over. As I read Salvation, Black People in Love by Bell Hooks, I heard Jerome's voice teaching me once again. During the time that Jerome was giving me and others books about love, he was writing about self-hatred. I've puzzled over these writings, but reading Salvation has provided some keys to understanding this work. Bell Hooks writes, "No one speaks about the topic of Black people in love without addressing issues of self-hatred." When Jerome was writing about self-hatred, he was really writing about love, as our good friend Adrian Davis recounted at his memorial last year. Jerome believed in the transformative power of love, and despite all the physical and psychological pain he experienced, he believed, as James Baldwin insisted, that we are always more than our pain. I didn't hear this earlier, but I hear it now. Thank you, Jerome. I crossed out my mileage plus number, so. One of Jerome's better-known pieces of legal scholarship is an essay that he published in the Virginia Law Review, Autobiography and Legal Scholarship and Teaching, Finding the Me in the Legal Academy. He wrote that who we are matters as much as what we are and what we think. It is important to teach our students that there is a me in the law, as well as specific rules that are animated by our experiences. And being the law geek that I am, you'll notice there's a pin site for this quote. So following along in terms of autobiography, and also what you heard in the short video, I'm going to begin by talking about where and when I enter. I was born in Korea. And I say Korea, I don't say South Korea, although it was South Korea. And I say Korea because the division between North and South, that is the product of the imperial powers. And the line that divides, I regard as this wound that is never going to heal, despite the hope of someday a unified Korea. I came to the United States in 1970, and so becoming Asian American is something that I became. So Asian American is something that I became. I wasn't born Asian American. And that's something that I return to in my work. I happen to grow up in a small town in Ohio, a town of 3,500, 99.999% white, which explains in some ways why I can't even pronounce the name, my first name that my parents gave me, Sungcho. When we came to the States, they decided to name me Robert. If you're wondering why or how I became Bob, I went to kindergarten as Robert. There are 3 Roberts in the class. The kindergarten teacher looked at white Robert number 1 and said, "What do you want to be called?" He said, "Robert." She looked at white Robert number 2 and said, "What do you want to be called?" He said, "Rob." So she looked at me and said, "I guess you're Bob." So I went to school Robert, first day of kindergarten, half day, and I came back Bob. I explained to my mother, I'm Bob. Like, she didn't know what to do with that. It's like, I guess that's what happens when you go to school here. So the other thing, though, about growing up in Ohio is that my formative experience with racism took place when I was in 6th grade. And I endured a month-long festival of name-calling, things that people who look like me are usually called, fought back as I could. It all stopped finally one day when a student called me the N-word. And there was a part of me that wanted to say, "But sir, I'm not." But in some ways, I was that to them. I was the other in their midst. And although I would never claim to know what it is to be black in America, I do know what it is like to be an other. And that's the place that I go to when I try to think about the coalitional work that I do. And that's a place that I encourage all of you to go to, because I know all of you have experienced being an other in some fashion. And so I encourage you to think about that place of otherness. Now, the problem was, I wasn't equipped to deal with racism. Didn't learn about really African American history, Asian American history, what's that? And so I put that experience and those feelings in a box, and I just put them away in the closet. I decided that I would insulate myself through achievement through excellence, that somehow being better than everybody would shield me from racism. You know, like, that's pretty stupid. But I didn't know. I didn't have the words. I didn't have the language. I didn't have the ideas or the theory until law school. It wasn't in college either, because I majored in molecular biology. I didn't teach feminist theory and critical race theory and molecular biology. But in law school, I had the good fortune of being here and experiencing this symposium every year that Duke Law Journal had, Frontiers of Legal Thought. I think one of the pictures there of the panel where Jerome was speaking with some others, I think that was from Frontiers of Legal Thought. And so I heard these people, Angela Harris, Derek Bell, Jerome Culp, Patricia Williams. And you're like, well, that's when you heard him? And it's like, yes, because during my 3 years here, I never took a course with him because half the time he was away on protest visits because he was tired of being the only black faculty member on this faculty. So how does he affect things? Well, he goes on protest visits. So I didn't have the benefit of learning directly from him, but I learned from his words. One of his articles, Toward a Black Legal Scholarship, Race and Original Understandings. And so my first article, Toward an Asian American Legal Scholarship. And the Oscar Wilde quote, imitation is the sincerest form of flattery. And I usually forget the last part of it, right? That mediocrity can pay to greatness. So the greatness, of course, is Jerome, and mediocrity is who you're stuck with. But he gave me the courage to speak. And at the beginning of my article, I begin with the prelude of the different voices in which I speak. I've been most comfortable with the one called silence. Silence allowed me to escape notice when I was a child, and I could become invisible and hence safe. Yet now I find myself leaving the safety of my silence. I wonder if this is wise. And then I recount some experiences that I have had with racism. These are the thoughts that intrude. I try to push them away. I try to silence them. But I am tired of silence, and so I raise my voice. He did me the honor of inviting me to co-author a few pieces with him. My presentation is called, How Do We Come to Participate in the Struggles of Those Who Are Not Us? He spoke these words at the first LACRA conference in 1996. And I always go back and reflect about those words, the challenge that he was presenting to us. The other thing about that conference is that his father flew out to join him at the conference, and I met his father. And then, because his father is of the generation that doesn't fly across country and just go for a few days, his father had actually planned to stay a week. Jerome didn't know that. And Jerome had stuff to do to go back to. And so his father was just going to wander around by himself, so I invited him to stay with me. And so he exhausted me. So I asked him, what do you want to do? Tijuana. So we went to Tijuana. SeaWorld. We went to SeaWorld. Bowling once or twice every day. He exhausted me. But it was really, I think, that the hospitality and care, the relationship that I developed with his father that led to the deeper friendship with Jerome. So, hypothesis. We are not able to participate in the struggles of those who are not us because we do not see ourselves in them and feel that they do not see themselves in us. So that's the hypothesis. And so from this, I think, well, how do we overcome that? And Brian Stevenson of the Equal Justice Initiative, the founder of it, talked about how the North won the Civil War, but the South won the narrative war. And so when I think about the hypothesis and how do we come to participate in the struggles of those who are not us, I've realized, oh, I'm engaged in a narrative project. So narrating a story of America that is different perhaps from the way that many people have heard this story. So that's the idea. I think about things like the racial project that I call America. And so for me, it goes back to Bacon's rebellion in 1676. So when I'm trying to understand today's racial fissures, I go back to the Bacon's rebellion where approximately 6,000 indentured European servants, bondsmen, joined together with approximately 2,000 indentured black people, enslaved black people, and free black people. They joined together. They rose up. They went and burned Jamestown. They didn't ultimately succeed in what they were trying to accomplish, but it scared those with privilege. It scared white property owners. And so then they began thinking about, well, how do we ensure that those at the lower strata, regardless of color, black and white, how do we make sure that they don't join together to disrupt the power relationships? And so they systematized things. And so black people got harsher punishments for doing the same things that white people did. If a black indentured servant ran away, well, enslaved forever and became hereditary, where the white indentured servant who ran away might just get some added years. Black people couldn't have weapons, and on and on and on. All these differences that are put into law to make sure that there is a divide. And here's the thing about it. When you create a system of disability and privilege, you need to remind people of it constantly, and this is before social media. And so in this book, The Invention of the White Race, parish clerks or church wardens, once each spring and fall at the close of Sunday service, should read these laws in full to the congregants. Sheriffs were ordered to do the same thing at their courthouses. Because it's not enough that these differences exist, you have to remind people of them. And that's part of making it all systematic. The racial compromise gets carried forward into the US Constitution that could be called a racial compact. And despite the Civil War and the Reconstruction Amendments, and then followed by redemption after the Union troops are pulled out of the South, what we see is a periodic renewal of this racial contract, this racial compact. And so W.E.B. Du Bois, in a brilliant book, Black Reconstruction in America, talked about how it must be remembered that the white group of laborers, while they received a low wage, were compensated in part by a sort of public and psychological wage. So you're not going to give them money, but you give them a social and psychological ways to have them buy into the system that oppresses them, but they get some privilege with it. The Negro is subject to public insult, compelled almost continuously to submit to various badges of inferiority. The whites fearing to be supplanted by Negro labor, and the Negroes always being threatened by the substitution of white labor. Stratification that produces insecurity, that produces a compliant workforce. White labor saw in every advance of Negroes a threat to their racial prerogatives, a certain notion of this being a zero-sum game. The other thing about whiteness is, well, whiteness is artificial. W.E.B. Du Bois in 1910 wrote, "The discovery of personal whiteness among the world's peoples is a very modern thing, a 19th and 20th century matter indeed." This is carried forward by the historian Nell Irvin Painter, fantastic book that came out in 2010, where she says the same thing. Whiteness is still evolving. We're seeing that right now. We're seeing that in the context of cases like SFFA versus Harvard in North Carolina. And I think that we are seeing an intensification of white racial identity. And in terms of the narrative war, we're not winning that narrative war. And we need to think about that. Now, from there, right, and I realized, like, wow, I went from Bacon's Rebellion all the way up to here. This is in very summary form. If you want to talk further with me, I'll just be happy to sit down with you for a few days. So 2 books that I'm sitting with now are the book by Ned Blackhawk, The Rediscovery of America, and a book that came out a few years ago by Laura Gomez. And those are more specific accounts of those stories And if you're less familiar with those stories, I encourage you to look at them. And now I'm going to turn to something that I've studied a little bit more, Asian Americans. And I get to also talk about Fred Cormant's. So when I think about the differential racialization of Asian Americans, think about my first book, and this idea that one is not born an Asian American, one becomes one. And that comes from my own understanding of my identity, the me in the story. The invention of Asian Americans. Asian Americans is made up. Doesn't mean that it's not real. In the same way that sometimes people have asked, well, people say that race, blackness is socially constructed. Well, that means it's a fiction. But tell that to a black person who's trying to get a cab in New York. Doesn't really seem like a fiction. Social constructions are real. So then thinking a little bit about how this happens. So at the beginning of the pandemic, I got an email from TED-Ed asking if I wanted to do a lesson about Chinese exclusion and things like that. Got so excited because I get to do a TED Talk. And they wrote me back and said, no, you get to write a script for a short narrated video. And we're not even going to use your voice. If you listen to this 6-minute clip, it's like a British voice, right? It's not me pretending to have a British accent. But if they ever contact you after you get over your initial disappointment about not being invited to give a TED Talk, I encourage you to do this because this video has gotten over 1 million views. That's about 1 million more than my law review articles. So in terms of understanding the struggle that America had with figuring out what box to put Asian Americans, a case that I begin with is the 1854 case of People versus Hall. George Hall killed Ling Sing, and surprising that for the time, he was actually convicted of murder. But he appeals his conviction to the California Supreme Court and says, my conviction cannot stand because the court below, the trial court, admitted testimony by Chinese witnesses. And that's not right. But then we look at the statute. No black or mulatto person or Indian shall be allowed to give evidence in favor against a white man. And George Hall is white. What do you do with a Chinese person? And they called them Mongolians back then. What do you do with them? So the court there, after scratching its head and putting on its evil genius hat, decided that, well, Indians came from China, from Asia. And so the statute that references Indians includes people from Asia. Asians are Indians. Therefore, conviction doesn't stand. Then being a little bit uncertain about the sort of validity of that line of thinking, they said, well, the other way we could get there is black. Well, black just means everybody who's not white. Going back to the reasons why we don't want people of color to testify against white people, because it's about maintaining white privilege. And the Mongolians are not white, so you treat them the same. So black became the catch-all. After the struggles, in terms of the private struggles, and after the state of California tried to do immigration restrictions that got overturned by the US Supreme Court based on federalism grounds, there was a campaign to bring in Chinese exclusion by the federal government. And so we have these cartoons from that time on the left, throwing down the ladder by which they rose. And in some ways, it's a critique of European immigrants who came to the United States. And now they're trying to keep Chinese immigrants out. In the middle, what you see is European immigrants and a black person working together to build this wall. And so in some ways, the black person was able to participate, or at least they were appealing to black people participating in this effort. Now, the black press was fascinating during this period because there were some that did favor Chinese exclusion, but many did not. Frederick Douglass was famously against Chinese exclusion. And there's this one political cartoon that I wasn't able to find yet. The Google failed me, and I'm using the wrong AI, I suppose. But in this image, there's a brick that's labeled Chinese exclusion. It hits somebody who appears to be Asian, and then it bounces off of them, and it hits a black person. And so in understanding then that this is racism, even if it's directed against a group that is not black, it's actually in the long run going to reinforce white supremacy in a way that black people are going to be harmed. How do we come to participate in the struggles of those who are not us? Back to that question. Those efforts, political efforts, succeeded. And so then you had the 1882 Chinese Exclusion Act. But that's the action of the political branches, Congress and the executive. What about law? And this is where the treatment and the otherization of Asians becomes written into the Constitution. So Che Chang-ping and the terrible, horrible, no good, very bad day. So Che Chang-ping came to San Francisco, excuse me, in 1875. After spending at least 12 years here, he decides to visit his family in China. So he goes in 1887. He follows the rules because in 1884 they passed a law that said, well, you can go back, but if you want to return, you need a certificate of return. He followed the rules. He got this certificate. He boarded a steamship on September 7th or September 8th, and then transportation technology being what it was, when he arrived on October 7th or October 8th in San Francisco, he wasn't allowed in. But he said, but sir, I have the certificate. On October 1st, the president had passed into law the Geary Act, 1888, that negated all of these certificates, stranding possibly 20,000 people of Chinese ancestry overseas. Now, how could that happen? That doesn't seem right. Like, he followed the rules. He had the return ticket. Well, we find that there are differences that then get built into the Constitution. And when I think about the Constitution, I think about not just the text of the Constitution, but the way that the court interprets it, because that's what we experience. We have the story of Marbury versus Madison, judicial supremacy, checks and balances on the excesses of the political branches. But with regard to immigration, if Congress decides that there's a group that we don't want, that we don't think fits, this determination is conclusive upon the judiciary. And so in Che Chang-ping, they stand down, and it writes into the Constitution a deformity called the plenary power doctrine. The other thing about the plenary power doctrine is that it's a doctrine that applies with regard to our colonies. And what's common about the people in our colonies? They tend to be of the darker hues. And then with regard to Native Americans, Indians, plenary power. So we exclude certain groups from the full protection of the Constitution. Managing the Asian threat. Earlier, before the Chinese Exclusion Act, there was a facially race-neutral act called the Page Act. And your dean, Carrie Abrams, has written extensively about this, including the impact on Asian women immigrants. After the success of keeping out Chinese labor, well, here's the thing. Capital has a thirst for cheap labor. So the next group after the Chinese became immigrants from Japan. Well, immigrants from Japan were then seen as a threat. And so you have the so-called Gentleman's Agreement of 1907 to 08. And I don't really understand why it's 07 to 08. I haven't figured that out. It's like, did the handshake take place over midnight? I'm not sure why it's called that. But after Japanese labor is stopped, capital has a thirst for cheap labor, they next went to South Asia. The next immigration restriction was not done in a facially race-specific way. They did Asia by longitude and latitude. And actually, I think it's the first Muslim ban, because when you look at the area that's covered, so that was actually the first Muslim ban. After that, immigration from Asia is largely cut off completely based on the 1924 Immigration Act, because aliens ineligible for citizenship, those who could not naturalize, were then not permitted into this country. But there was a loophole. Filipinos started to come. And they came because the Philippines was a U.S. colony, so they came in originally as U.S. nationals. When they were deemed to be a threat, I keep talking about the evil geniuses, But what they decided in 1934, they told the Philippines, we're going to give you independence in 10 years or so. And because we're going to give you independence in 10 years, you're no longer U.S. nationals. We'll pretend that you're something else. And that's how immigration restrictions operated there. So what we see then is that there are similarities in the techniques that are used with regard to the Chinese that are developed, and then they are transferred to other groups, Japanese, South Asians, and Filipinos. We then get exclusion from the national body. The 1790 Naturalization Act, free white persons could become naturalized. 14th Amendment, we get the Citizenship Clause, and then Naturalization Act of 1870, white persons and persons of African nativity and African descent could become naturalized. What about Asians? So, in Ozawa versus United States, Takao Ozawa presents himself to the court, and he understands like there are two doorways into like the country for naturalization. There's the white door and there's the black door. He tried to come in through the white door. He presented his skin to the court and said, I'm white. And he tried to say, I'm paler than so many Europeans that you allowed to be naturalized as white. The court looked at him and said, nice try, and they disregarded scientific ethnographic testimony by a cultural anthropologist. They found, I don't know where they found this person, but the report of his travels talked about seeing the white people of Japan. It's like, see? White people of Japan. They said, no, white equals Caucasian. This was then thought to provide a pathway for South Asians, because according to ethnographic theory at the time, they were Aryan. And so this case was coming along. The US Supreme Court had not anticipated it. He said, you just the last term said white equals Caucasian. I'm Aryan. I'm more Caucasian than you are. And the court said, well, let's take a step back. White will go with common sense notions of whiteness back to 1790. It's like, they would not look at you and say you were white, and therefore you're not. So Asians became ineligible for naturalization in another way that the US Supreme Court then allows the actions of the political branches to then be written into the Constitution that excludes people of Asian ancestry, unless you were born here. So Wong Kim Ark, and based on the 14th Amendment, you would get citizenship. But once you get the racially neutral category called aliens ineligible for citizenship, then you get all manner of other mischief that follows. The alien land laws. Everything old is new again. In Florida, just this past year, a judge, Judge Alan Windsor, said that, well, sure, it targets people of Chinese ancestry, but it's based on people who are domiciled in China. And then he says, well, you could have a Dutch person who is domiciled in China, and so it's not racist, Florida's alien land law, and cites, too, the 1923 case of Terrace versus Thompson and says, that's never been overturned, so I'm going to stick with that. But the idea here is that discrimination is what produces the Asian American racial subject. Then, by the time you get to World War II and the otherness of people of Asian ancestry is written into the Constitution, then you get national security exceptionalism. FDR signing Executive Order 9066. The first civilian exclusion order, number 1, hit a community near where I live in Seattle, Bainbridge Island. And those are pictures of that community being taken off the island. I don't know if you can see the picture in the middle top, but I see apprehension in the mother's face. I see sort of an appearance of a feeling of being lost, the child on the left, and then I love the child in the front. She looks angry. It's like, so I sort of want to channel that. So most of the people in the Seattle area went to Camp Minidoka in Idaho, but I love this picture because of the ironic juxtaposition of the US flag in the incarceration camp. I think about 4 people who challenged the laws that put them there: Minoru Yasui, Gordon Hibayashi, Fred Korematsu, and Mitsui Endo. A lot of people don't know as much about Mitsui Endo, and in part because her case was not decided on constitutional grounds. And then the other thing is, what's funny is, She's the only one of the three that won her case. It's like you would think that she'd be the one that was celebrated and honored. But it's the three men who lost their cases who tend to be remembered. I'm not going to worry too much about that because my center is named after one of them. But Misui Endo was a California civil servant, and when the war broke out, she was fired along with everybody else of Japanese ancestry. She joined a group that sued the state of California for unlawful termination on racial grounds. While she was doing the lawsuit, she ended up being placed in an incarceration camp. A lawyer went to her and said, "Do you want to challenge your incarceration?" And she said, "Yes, I do want to challenge my incarceration." And a habeas corpus petition was filed. The court there decided that the War Relocation Authority didn't have the power to hold somebody whose loyalty had been determined to be good. Like they have decided that she is a loyal U.S. citizen. They can't hold her. So she wins her case, but they don't do anything beyond the relief that they gave to her. They also delayed the issuing the habeas order, and there are papers from the justices where one justice is like, why haven't we issued it? Why isn't she free? And they were actually waiting for FDR to make an announcement he was going to close the camps. But he actually didn't close the camps for months after that, despite this court ruling. The three men challenged the curfew. Well, the two, Minyasu and Gordon Hirabayashi, and Gordon Hirabayashi and Fred Koromasi challenged the evacuation order, the order that said that you had to leave. So Fred was a welder, 22 years old, and he didn't want to leave. He thought this was wrong. He got arrested, and then when in jail, Ernest Bessig of the ACLU came to him and said, "Do you want to challenge this? I would like to find a test case." And Fred said yes. He lost, was convicted, appealed to the U.S. Supreme Court, and I think we all know what happened there. He lost again there. But in 1981, there was newly discovered evidence that the DOJ attorneys had withheld or misrepresented evidence to the U.S. Supreme Court. And so that actually allowed the cases to be reopened in the 1980s. Quorum nobis, most of us will never have to file a quorum nobis petition, but thankfully there was a pathway. And it was funny because there were questions like, where do we file this? Because quorum nobis is supposed to be filed in the court where the error was made. And so there was some discussion, file it in the Supreme Court, go for the home run right away. They decided to do it through the different district courts, so in San Francisco, Seattle, and Portland, and partly to give 3 chances for this to go up through the courts. In 1984, Judge Marilyn Hall Patel overturned Fred's wartime conviction. Now, one of the things that really troubled me about the Hirabayashi opinion that was written by Chief Justice Stone is something that I regard as the death of irony. In essence, what Chief Justice Stone is saying is that because we've discriminated against Japanese Americans and because we did such a good job of it, we need to keep doing it. And footnote 4, he goes into the list of things that the states and the federal government have done to people of Japanese ancestry. It's natural that they might not be loyal because look how we've done them dirty. The death of irony. Now, footnote 4. The other thing about Chief Justice Stone is that when he was Associate Justice Stone, he wrote Caroline Product's footnote 4. And unfortunately, in Hirabayashi, he forgot his earlier self. We're a discrete and insular minority. He just sort of ignored all of that. Now, there's a moment during the World War II where people of Chinese ancestry were getting attacked because people thought that they were Japanese. And so you have a Chinese reporters having a handwritten badge, Chinese reporter, not Japanese, please. Life magazine did a spread to educate people in the US how to tell the enemy Japanese from the friendly Chinese. So things like, apparently, Chinese people have parchment yellow complexion, whereas the Japanese, earthy yellow complexion. And then there's this other phrasing in there where Japanese apparently like stride forcefully forward, where the Chinese apparently shuffle along. Ways to tell the enemy Japanese from the friendly Chinese. You had then the self-defense reflex, where buttons were created. So these are lapel buttons that said, I'm Chinese, not Japanese. And you see what that workman has put on his back so that he doesn't get anti-Japanese hate. Now, as much as I understand that self-defense reflex, I also want to critique it because at some level, Americanness, or at least non-enemyness, was offered to people of Chinese ancestry. They accepted that privilege instead of showing up for people of Japanese ancestry. And it wasn't just the Chinese, it's like everybody didn't show up. So Fred Korematsu talks about when his wartime conviction in 1984 was overturned, the courtroom was packed. It was like, wow. And he felt so beloved by the community. But in 1943, when he was convicted, he was alone in that federal district court in San Francisco. And he said, I felt really alone. And so there's something about showing up for others, and there's something about what do you do when privilege is offered to you. Now, moving quickly, right? So I've been telling one story that was sort of an African-American story, one story that was an Asian-American story, and then I told you to read 2 books to tell stories of others. But when we think about race, what we also try to do is think about how does this all work together? And there's a sense that there is racial positioning that takes place. An example of early racial positioning includes how the Irish became white. So as an example, when the Irish first came to the United States, they were regarded as not white. They were regarded as racially inferior people. But they pursued a whiteness strategy. And so in Baltimore Port, at a certain point in time, the cargo ships were being offloaded by stevedores who were black. Irish workers who wanted those jobs said, public campaign, let's make this an all-white waterfront. Claiming whiteness for themselves, but in a way that subordinates others. So when I think about race hierarchies, I sometimes think about, well, people think about a top and a bottom. And then there's racial positioning that operates. There's a case out of Mississippi, Gong Lum versus Wright, 1927, where Gong Lum, on behalf of his daughter, Martha Lum, tried to get, said that she should be allowed in the white school because she doesn't belong in the colored school. At the time, they had schools for white students and black students. They didn't have a school for Chinese students. Now, the weird thing is that before this year, she and her sister had attended without any problem the same school. But what happened was more Chinese people came into this community in the state, and there became public press about this and the danger that Chinese people posed. And so then she went that first day, she was allowed, but she went home for lunch, and when she tried to come back, the principal said no. So they sued. But in terms of the tactical positioning, they could have tried to challenge segregation. And probably that would have been a loser, and maybe we would not have had Brown when we did if they had decided this on that ground. But instead, they chose to say, I'm not black. And they tried to say, when we're thinking about where Chinese people are, we're closer to white than black. And so in terms of the tactics of racial positioning, they tried to position themselves in alignment with white, not appreciating that if they won, in some ways it's a self-defeating tactic because it reinforces the system of racial subordination. The Mississippi Chinese here, the plaintiffs also forgot how they ended up in Mississippi in the first place, in the Delta. They were brought following the Civil War because there were white landowners who wanted a more pliant workforce. They didn't think the black people were going to be good workers, or they were afraid of them, or they were going to use the Chinese to then extract more from black people who would then be insecure about their jobs. And so they were imported as part of a racial stratification strategy. So it's always much more complicated. And then when you bring in more groups, you're actually able to make oppression work even better. And I think that's one of the lessons in terms of thinking about multi-group. So racial triangulation in Asian Americans. And so, there's this idea of going beyond black and white. While the multiracial composition of the American populace has always given lie to the bipolar racial framework, what does it mean to go beyond black and white in terms of thinking about race? And so what she posits is, well, what you have is not just one axis. And so then she was talking about foreigner and insider, inferior and superior. And so mapping it in a way, and in a moment I'll show how the triangulation actually allows you to do more, in part because it helps to divide more. Now, racial triangulation, one example of it is actually Plessy versus Ferguson. Justice Harlan's famous dissent, "Our Constitution is colorblind." But the context for this is, immediately before that language, "Our Constitution is colorblind," says the white race deems itself to be the dominant race in this country, and so it is in prestige, achievements, education, wealth, and power. So I doubt not it will be forever if it holds true to its racial heritage. One of the more naked pronouncements of white supremacy that I've seen to grace the U.S. reports. But the other piece of the opinion that is not included in most common law casebooks is the racial triangulation piece of it. Part of what Harlan was offended by was that a Union veteran who had fought, a black Union veteran who had fought to preserve the Union, could not sit in the white car with white people, but a Chinese person, and he says, people who we don't even let into this country, well, that person can sit with white people. So you see the triangulation. So black people at some level are brought to a more even horizontal line with white Americans against the real racial other. And in terms of Harlan and his colorblind constitutionalism, he was terrible with rights of Chinese people. Deployments. How do we see this operating? In the context of often affirmative action, Asian Americans are seen as a model minority on an even line with white Americans, juxtaposed against black and Latinas and Latinos. It's also used to criticize social safety net programs. But then when it came to immigration in the 1980s, black Americans were appealed to by immigration restrictionists because they said, you're American like us. You should join with us and support immigration restriction against the real others. But here's the thing. We see that these alignments are episodic. They don't persist, so that as a matter of convenience, you then are able to say, oh, join with us, but then in the next room over, they're stepping on you. Counter deployments. So I love examples like this. The Japanese-Mexican Labor Association, the Oxford Strike of 1903, successful. After its success, the AFL, the American Federation of Labor, writes to the Mexican-American workers and says, you can join our union, but you got to keep out the Asian brothers. And I love the response to the AFL. They said, no, these are our brothers. And so they were offered privilege. So the question is, when you're offered privilege, what do you do with that? Do you see the larger picture, and then do you reject the privilege, which might get you a short-term benefit, in line with the larger goal? And then Ralph Lazo, For the Win. So I had to look up FTW the first time I came across it, but that's For the Win. The younger generation doesn't need that explanation. But Ralph Lazo was a Mexican-American teenager who went to the camps with his friends. He suffered with them. And I just love that example. And so the question, when privilege is offered to you, what will you do? And then in terms of thinking about the long game, the narrative battle. So how do we come to participate in the struggles of those who are not us? How do we come to see ourselves in others? How do we see others in ourselves? Learn your history. So one of the things that I love about Jerome is just how voracious a reader he was. And he bequeathed me his books, and there's a special collection at Seattle University School of Law, the Culp collection, where you can see the breadth and width and like the craziness of the things that he cared about and read. Learn the histories of those who are not you. And that was Jerome. After that, it's on you. And then shifting to Fred Korematsu, show up for yourself and show up for others. I mean, that's the legacy that we try to advance in the Fred Korematsu Center. So show up for yourself, yes, but show up for others. So wisely, Baldwin insisted that we are always more than our pain, and Jerome wrote a lot about pain. And he was critical of institutions, including the institution at which he taught, because he loved it, he wanted to make it better. Not only did he believe in our capacity to love, he felt black people were uniquely situated to risk loving because we had suffered. And so when we think about love, I think about Jerome. I try to remember and channel that. And I'm going to end with a personal note. So that's Jerome and our good friend Adrian Davis. They co-officiated my wedding on December 21st, 2002. And then in terms of how generous a spirit he was, he flew out across country. He did 5 hours of dialysis the morning of the ceremony, and he came. He showed up because that's what he did. He showed up for others. And so I'm so honored to have been asked to deliver the inaugural Culp Critical Theory lecture, and I thank you.
Are you willing to take a few questions? Sure. Bob is willing to take a few questions, and we have some time for that. Any questions?
Here because Jerome Culp was a very good friend of mine. He had an office right next to mine, and also upstairs with David Lang, who is now not in good condition. So he was and he came to our home to eat, and he was kind of funny because he was a pretty big guy, and he broke a car, and he got so my Big D, that's my wife, who's 5'10", and she grabs him and says, "Don't worry about it." And the last thing I saw of him with Sarah Beale when he was dying in the hospital there, and we went that together, and we probably were the last two human beings seen who would see him here, at least people who knew him, right? So that's the reason I came, because I want to honor him. He was a friend, and he was a good guy. All right?
Thank you, George.
Okay.
Any questions?
All this makes such great sense. Why is critical race theory such a dirty word with these current people in these current times? What's going on? Thank you.
So the question was, why is critical race theory, or CRT, such a bad word, dirty word right now in the current times? So I attribute it to dog whistle politics. And dog whistle politics, there's a great book by Ian Haney Lopez, but it's an older term, of course, where in the old days you could just say the N-word and get people to vote for you or go along with what you wanted. But at a certain point in time, it became not polite to do that. And so there began the use of racially coded language. So things like, well, I'm not against integration, but I'm for integrated schools, and on, things like that. Things that become coded. CRT is serving as that, and so part of the hilarity of it is, if you ask sometimes people who say, well, we're against it, it's messing with young children's minds, and you ask them what it is, they don't know what it is, but they've heard enough people say that it's this terrible thing. And when we think about critical race theory now, well, in the early 1990s, critical race theory was also under attack in the legal academy. And it was thought of as a scary thing. And so then sometimes you had scholars who wanted to get tenure-track jobs at law schools, and sometimes they were told, don't let people know that you're a crit, because there's this idea or notion that you're not going to be a good institutional citizen, that you're going to do a lot to rock the boat. And even if you're not that, it becomes a way, a device, that can be used to promote a whole variety of different ends.
We need to get the truth out, right? Again.
You're right about getting the truth out, but I worry in this time when more and more truth seems to matter less and less with the public.
Thank you.
Yeah. You have a question about that?
Hi, Professor Chang. One of the things that you said during your talk is you had that great quote, the North won the Civil War, the South won the narrative war. And you said, we're not winning the narrative war currently. And I'd like you to just maybe talk a little bit about how you think, I think that kind of probably builds on the last question you got, but how do we approach this narrative war? Because a part of approaching the narrative war, I would assume, is kind of speaking that truth to power, recognizing that the ways in which they are trying to divide us is significant, divide us as in people of color, right? Try to keep us separate, try to say, Asians are models and blacks are not, and black immigrants are even better than black Americans, right? And so doing that work, and we do some of that work for white supremacy. So how do we do that narrative work while not stressing the things that have been created to try to divide different communities of color?
So the quote is from Brian Stevenson. And I'm trying to make sure to honor the person who said it and who is advancing it in a fascinating way, including by the museum that he's created in Montgomery, Alabama, the legacy sites, the reminders of history as a way to remind people that when we look at the trajectory of violence, that it's not something that was a long, long time ago. And then the other thing, that it wasn't just the South. I was walking around in Indianapolis in November at the NAPABA, National Asian Pacific American Bar Association conference, and I ran across one of the lynching sites, like the little memorials. It's like, wow, in downtown Indianapolis. And I love that visual reminder of it. And so part of what he's been trying to do is remind people of that history, but then also to have us think about, well, what things have we not fought enough about or for? So when I think about the narrative war, I think about the very different history that we find in Justice Ketanji Brown Jackson's dissent in SFFA, where she documents, well, where are we now in terms of societal discrimination? Now, I've been thinking a little bit about that phrase. Why is it the courts can't remedy, or why can't the 14th Amendment reach societal discrimination? Where does that limit on remedial authority come about? Well, that phrase actually only comes about in Justice Powell's concurrence in Bakke. That's the first time that phrase comes about, and we didn't fight back against it. We've kind of accepted it. And then we've accepted that, well, when we're thinking about discrimination, we need to think about the discriminator, and we need to be very narrow in terms of the way we think about the discriminator, instead of thinking about enlarging the temporal frame. And that's the thing that I love about Justice Jackson's dissent in SFFA, where she broadens the temporal frame, broadens the cast of characters in terms of who participated in this, so that we're not just thinking about, oh, did this particular entity do something bad to this particular person, because we've allowed ourselves to be boxed in by Washington versus Davis, intentional discrimination required for the 14th Amendment, and then McCluskey versus Kemp, well, too much discrimination is just too much justice. So we can't even touch something like that. And we just need to keep telling the stories. That's partly why I'm so invested in the educational project in law school. I'm teaching common law for the first time this year, and it's like, I'm having an existential crisis. Like, what is even con law? And I'm supposed to teach this to my students. I still believe, and this is also channeling Brian Stevenson. Despite all the stuff he has seen and has fought against, he says he still believes in the rule of law. I haven't given up on that enterprise, and that's what I try to do in law schools, in the conversations that I have, in terms of being able to teach students in the big classes, and then also in smaller settings, clinic, by training them to do this work.
And we have time for one more.
Hi, I'm Jaya. I'm in my final year here at Duke, and I'm a student in Professor Martinez's readings for race in the legal profession. There were two things that stood out to me in both your talk and the video that we were watching before, and both of them centered around this idea that, the man in the video, he was saying that he's not as naive as he was as a law student about law being the way to change society. And then you were saying that, you found, basically you entered, this whole discourse in law school. For those of us that are getting ready to leave academia and enter, careers as lawyers, how do we, what do you think the role of, of lawyers and practice, or I guess lawyers that are practicing in careers, maybe in corporate, what do you think that we can do to kind of encourage progress on this issue and keep this narrative alive and moving in the right direction?
So many Duke law students go work for big law firms, and that's all great. Many students, when they came to law school, wanted to make a difference, and that's all great. And so what I'm hearing a little bit is, well, if you make that choice to go into private, big-ish law practice, how can you still stay true to those commitments that you had? So one of the things that I hope is instilled in all of you in this fine law school that I also graduated from is a sense of purpose and mission, including notions of public service. Now, I have a very Big Ten approach to thinking about public service. So I'm not doctrinaire. I'm not somebody who says, well, you need to do this, or you're just part of the problem. The other thing that I also recognize about my own complicated positionality is I'm complicit in the system. I'm helping to make more lawyers, and not all lawyers are going out there and remembering some of the things that drew them there. And so I would encourage you, when you go out to practice, to also then think about mentors in your firm who are committed to doing good in the different places that they are doing good. Because there are so many different ways that can be done. Helping one person, that's great. Do that. Big impact litigation, those are harder, and it's hard sometimes to get a firm to commit to something like that. I was lucky in Arizona that I got a big New York law firm, Waugh Gottschall, after remand to trial to go through discovery and take it to trial. They put in about $4.5 million of time and hard costs. They believed in it, they were committed to it, and there are ways then to get involved in projects like that. Today, there's a New York law firm that is filing an amicus brief on behalf of Black scholars and race and justice centers to get the Ninth Circuit to recognize an intersectional Batson challenge. And yes, it hasn't been filed yet, and maybe I shouldn't talk about this, and I don't know if PR people are going to say anything about that, but it's the immediate example that came to mind of one of the ways that you can give back. And if the next election goes in a certain way, we're going to be doing a lot of work, and we're going to be needing a lot of help. And the last time it happened, we had a lot of help because people saw that many of the things, the travel ban, rescission of DACA, the census citizenship question, were wrong. And there are people who are committed who will do this work, try to find those people, and get on their teams.